now turn to the grounds of challenge. We've got 8 grounds of appeal. The 8th ground is a proportionality ground, and there's a little bit of overlap with the grounds my learned friend advanced this morning. And to the extent that our arguments are the same, we of course adopt all his submissions. But our case goes further. We say there is a principled objection to the imposition of taxes on education. And we attack this on various ways. The first is we're looking under Article 1 of the first protocol, which defends property rights. But these are obviously in the relation to the case that that the appellants advance. This is in relation to their religious rights as well. So the claims are to a certain extent linked together, and there is also overlap in the authorities with regards to the prohibitions on discriminatory approaches when governments impose regimes which offer advantages to groups of people and not to others. But starting on ground 1, Article 1 of the first protocol, we say is engaged. The divisional court found it wasn't, and then said, and even if it was, the purposes of Article 14, that it would be justified the measure would be justified and the restrictions would be justified. And their analysis, their discussion is at paragraphs 238 to 249. And I'd like to start by looking at paragraph 245, where they relied upon the ban in hunting in the Countryside Alliance. And they say, in the second part of that paragraph, that they're seeing the imposition of VAT on private education being more akin to a ban on handguns or the ban on hunting in the Countryside Alliance case. They say
where are you reading?
This is 245.
245.
It's the second part of it. It's the end of that paragraph.
Yeah. Yeah.
They say if these, i.e. the ban on hunting, ban on handguns, if these did not engage the Article 1 rights of the owners of businesses affected, then a fortiori, neither does the measure challenged here, which is liable to make it more difficult for some customers to continue to purchase the relevant services as opposed to preventing them being offered at all. If we look, the problem with that analysis of the divisional court is that it's factually incorrect. The Countryside Alliance case, in fact, determined that the Article 1 First Protocol rights were engaged, and we can see this in the judgment of Lord Bingham, paragraph 20 of that case. It's tab 22, 303 of the authorities bundle. And Lord Bingham's judgment, with which various other members of the court agreed, paragraph 20 on page 331.
Yes.
Says that these various people involved who impacted by the hunting ban had lost their marketable goodwill, and then he went on to say that nonetheless this was justified. And we then see at page Lord Hope at page 346, paragraph 65. For all the reasons that Lord Bingham gives, however, I agree that Article 1 of the First Protocol is clearly applicable to the complaints of some of the claimants, and that for this reason it is necessary to consider whether the interference imposed by the Act can be justified and is proportionate. And then Lord Brown, paragraph 146, says he completely agrees with Lord Bingham. That's page 366. And he says Article 1 of the first protocol is plainly is engaged, he says. So this is an error by the divisional court, and we say it's reflected in the approach that they took to the analysis of this article. We accept, and there isn't a dispute, that there's a distinction between marketable goodwill, which is protected by Article 1 of the first protocol, and loss of future earnings, which isn't. But the claimant schools in this case, their rights, their property rights are impacted because a law has been enacted by Parliament which directly targets them and directly renders them, puts their existence in doubt and puts them at risk of being unviable. And the two cases, the two authorities I'd like to take the court to are the Breyer Group.
I'm so sorry, just before you take
Yes.
us to those, I just want to see how broad is this submission. Would this apply, for example, to Eton?
Yes. If the submission is this, that if their viability is threatened, then it would apply. I don't know if Eton's viability has been threatened by this measure. It probably hasn't. But the evidence is that the schools in this claim, their viability is threatened, and that's what their concern is. The Breyer Group case can be found at tab 27, page 532, and it was a case which concerned guaranteed energy rates for electricity generating companies, which in turn were to be paid by electricity supply companies. And a scheme was put in place which was going to fix these rates for 2 years. But then at a certain point, the government changed the terms of the scheme and reduced the time for registration for these new photovoltaic installations. And the result of that was that some of the electricity generating companies who had putting in place the project but weren't going to be able to get it ready in time for the new deadline had to pull out, and they suffered losses as a result. Now what then happened in subsequent JR, in judicial review proceedings, which went to the Court of Appeal, determined that this change of cut-off date was unlawful. And so the scheme was never in the end implemented, but it was too late by that stage for the companies which had already discontinued their projects. And so they then sued, and the question was whether they had a right to compensation under Article 1, or whether they'd merely lost the right to future earnings, which isn't protected by Article 1. And the Court of Appeal acknowledged that the distinction between goodwill and future income is not necessarily straightforward, and various of the authorities mentioned this, particularly when the valuation of goodwill may include a component related to anticipated future income. However, they say at paragraph 44, on page 549, trying to understand what goodwill is, they cite with approval Lord Macnaghten in a case called Inland Revenue Commissioners and Muller, and there they provide a definition of goodwill, which the Court of Appeal, Lord Macnaghten provided a definition which the Court of Appeal approved of. He said it is the benefit and advantage of the good name, reputation, and connection of a business. It is the attractive force which brings in custom. It is the one thing which distinguishes an old established business from a new business at its start. The goodwill of a business must emanate from a particular centre or source. What was important is that the Court of Appeal found in Breyer, and this is paragraph 71, page 556, that where a business is rendered unviable by government action, then Article 1 is engaged. And this is what the Court of Appeal says. In my view, the judge was right to conclude that the proposal interfered with the claimant's Article 1 rights. Paragraph 52 of the assumed facts states that the proposal had an immediate and serious adverse impact on the claimant's businesses. So so that it was not economically viable for them to continue with their business in relation to the installation of solar PV systems.
Is that what the evidence shows in this case? You used a different expression. You said that this applies where viability is threatened.
It certainly applies with human rights have to be practical and effective and not illusory. We can't wait until the schools are rendered unviable before we're entitled to make a claim under Article 1. And that's the evidence before the court is that this is likely, and the government's acknowledged it. We saw my learned friend took the court to Treasury paper, which showed that it was anticipated this was going to have an effect on small schools, and the risk is a real risk. Now, none of them have yet shut down, but the risk is there, and that's the first way in which the right's impacted. When we get to the second authority, which is Van Maal and the Netherlands, we also see that the Strasbourg court has recognised a clientele as representing part of goodwill which is protected by Article 1. So even if a school isn't rendered unviable, but its clientele is reduced, then we say that also means that Article 1 is engaged. Van Maal against the Netherlands is at tab 42, page 1295. And this concerns a claim made by accountants who were not able to continue their business due to new registration requirements introduced by the state, which they no longer satisfied. Now, I appreciate it's a case where their business was terminated. But what's important here is what the court said about clientele constituting goodwill. And if I could take the court to page 1303, paragraph 41. The court agrees with the Commission that the right relied upon by the applicants may be likened to the right of property embodied in Article 1. By dint of their own work, the applicants have built up a clientele. This had in many respects the nature of a private right and constituted an asset, and hence possession within the meaning of the first sentence of Article 1. This provision was accordingly applicable in the present case. So what we say the government has done is to introduce a measure which, as the government recognises, it will reduce the size of clientele in the private sector, will lead to school closures, and on the appellant's evidence threatens this to such an extent that their very existence, they say, is at risk or serious risk. So we say the Article 1 is clearly interfered with respect to the appellant schools, and the Development Court was wrong to have held otherwise. This doesn't say anything about justification, but we need to establish that Article 1 was engaged, and we say it was. As far as the parents are concerned, the parents' property interest is an interest in the additional money which they now have to pay to ensure that their children can continue receiving an education which is, one, consonant with their religious requirements, and two, in any case, is an education that they have committed to and which cannot, without prejudice, be interrupted halfway through an academic year or halfway through an academic course. And the parents, we say, are captive taxpayers in these circumstances. The government's response, well, there's no obligation for parents to pay VAT because we provide perfectly suitable education free of charge. Well, we've seen the response to that. It's not suitable to the appellant parents. And it's also entirely unrealistic for parents to change their children's education halfway through their educational course, let alone halfway through the academic year. And I should note, on the evidence, some of the Christian students are following curricula which lead to examinations which are not available in the state sector. The branch school, and we can see this at witness statement of Jill Holt. In the supplementary, in the supplementary bundle, page 72, and that school provides an education curriculum called the International Certificate of Christian Education.
Is this the first supplemental or the rest?
It's the first one. It's paragraph 6 of the page 72. So the pupils are following a course which just isn't available in the state sector at all. So if they were to have to pull their children away halfway through the course or halfway through the year, it's going to cause even more prejudice for those students. And what I would like to take the court to show an example of a government scheme which was deemed to be convention compliant, it's very different from this one, which we say isn't, is the case of Begbie and the Secretary of State for Education. And that's at tab 18, page 173 of the authorities bundle. And that was a case which concerned a challenge to the government's abolition of the assisted places scheme. And the question was whether the claimants had a legitimate expectation that the scheme would be retained for the current beneficiaries of the scheme, so that those, particularly starting at primary school under the scheme, would be able to be guaranteed an education all the way to university. And the scheme said no, that you would only be educated up until the next level of your education. And this is explained, the background to that is explained, rather the factual background is in the government circular on page 177 at C. And that explains that an 11-year-old pupil in receipt of secondary education in a school which takes pupils to age 13 will keep their place until that age, but won't go on to the next stage. Whereas if one's an 11-year-old child in receipt of secondary education would be able to continue being educated under the scheme until 18. And then the important point right at the end of that, of the government circular, is this. There is a discretionary power which provides for extended support beyond the end of primary education. And it's this discretionary power which doesn't exist in this particular legislation, which is, we say, at the root of a lot of proportionality problems if we get to proportionality. So we say that the Article 1 rights of both the parents and the schools are engaged. And we'll get on to proportionality and justification in grounds further on. Turning now to ground 2, which is public interest ground. What we say here is that Article 1 has a threshold requirement that requires that any measure depriving someone of their possessions has to be in the public interest. And this is a separate requirement from the proportionality requirement. And it may be a requirement which is, in most situations where one's dealing with government taxpayers, it may be a requirement which is easy to meet. But it's nonetheless a requirement which the court will have to assess. And the authority I'd like to take the court to is a case of NKN against Hungary, tab 55, page 1712 of the authorities bundle. And this is a case which involved a civil servant whose severance pay was taxed at a much higher rate than other people's were on their income. And we see this at paragraph 7, page 1715. It was 52% total tax burden 16%, which other people would have. And she challenged this discrepancy. And then at paragraph 55 and 56, the court said, considered the public interest requirement in the context of taxes. And the court said this: the applicant challenged the legitimacy of the aim pursued by the impugned measure. In this connection, the court reiterates that because of their direct knowledge of their society and its needs, the national authorities are in principle better placed than the international judge to appreciate what is in the public interest. Under the system of protection established by the Convention, it is thus for the national authorities to make the initial assessment as to the existence of a problem of public concern, warranting measures of deprivation of property or interfering with the peaceful enjoyment of possessions. I'll carry on reading because otherwise Sir James will ask me to carry on reading. Here, as in other fields to which the safeguards of the Convention extend, the national authorities accordingly enjoy a certain margin of appreciation. Furthermore, the notion of public interest is necessarily extensive. And then at 56, the court further reiterates that the levying of taxes constitutes in principle an interference with the right guaranteed by the first paragraph of Article 1, and it will then fall to be justified. So that supplements our first ground. When we look at ground 6 and the question of the margin of appreciation, and notwithstanding what the court said, that in general there's a very broad margin of appreciation in matters of taxation, in the present case, our submissions are that the margin of appreciation in this case, if it exists at all, is in fact very narrow. And that this is in fact the case where the court is qualified to assess the public interest question. And the reason it is because public interest in the field of education has, we say as a matter of law, been established, rather than non-taxation of education has been established as something which is necessary in the public interest. And we rely in particular on the EU VAT directive, where we say that's defined as a matter being in the public interest, but not just under the EU VAT directive, also under domestic law. The charity law establishes provision of education is in the public interest. And what we now have is a law which undermines the public interest in order to promote the public interest. And we say this is something the court is able to assess whether that's possible. And we say the VAT measure faces two difficulties. The first is because the money raised by the measure is non-hypothecated, that is, the VAT income goes into a general tax pot. It's not ring-fenced to fund state education. The general interest, therefore, is simply the raising of tax revenue. That's what it reduces to. What's the general interest? Well, we're just raising taxes. But if the raising of tax revenue was always in the public interest as a matter of definition, then there would be no need for court supervision as to this requirement from the dealing with taxation cases. But NKM shows that supervision is still called for. In NKM, it would appear that the situation that the government was responding to at the time of that case was a situation of general financial crisis and cuts which were being made to the public sector. And it seemed that there was a sense of social justice of the population was offended by people whose jobs were being public servants, whose jobs were being cut, then getting very big payouts. And so they were trying to claw some of that money back. But nevertheless, the court at paragraph 59, page 1729, accepted that the sense of social justice of the population, combined with the need to protect the public purse, could satisfy the public interest requirement in that case. But the difficulty in this case is that there's no nexus between the property removed by the state and the general interest served in this case, because the two interests at stake are not competing. Parents deciding to send their children to private school do not damage or compromise a general interest, saving the state money. Secondly, we observed that at paragraph 95 that the divisional court recognised that there was no dispute that the services provided by private schools do serve the public interest. And we say that as a matter of law and logic, it is not possible in this case to further the public interest by undermining the public interest. And so this is a case where the court can say that the threshold requirement wasn't met. And before I leave NKN, I wanted to just deal with, because we have the authority before us, to deal with proportionality considerations, which were important in that case too, and are important by analogy to this case. In NKM, the Grand Chamber found that the tax, despite arguably being in the public interest, was not proportionate. And this was because the money raised, whilst it was being raised to fund the general public purse, as in this case, a certain segment of the population was being asked to shoulder a disproportionate burden. There was no reason, the court said, to single out particular types of civil servants to solve the budgetary problems of the country as a whole. And we can see this in paragraphs 71 and 72 of the judgment, pages 1731. In the court's view, the applicant, together with a group of dismissed civil servants, was made to bear an excessive and disproportionate burden, while other civil servants in comparable statutory and other, with comparable statutory and other benefits were apparently not required to contribute to a comparable extent to the public burden, even if they were in a position of leadership that enabled them to find certain contractual benefits potentially disapproved by the public. Moreover, the court observes the legislature did not afford the applicant a transitional period within which to adjust herself to the new scheme. So that goes back to the Begley point that we made before. And then at 72, against this background, the court finds that the measure complained of entailed an excessive and individual burden on the applicant's side. This is all the more evident when considering the fact that the measure targeted only a certain group of individuals who were apparently singled out by the public administration in its capacity as employer. Assuming the impugned measure served the interests of the state budget at the time of economic hardship, the court notes that the majority of citizens were not obliged to contribute to a comparable extent to the public burden. So we say the same principle applies here on proportionality grounds. We've subset of the population has been singled out to bear the burden for the rest of the country. And furthermore, these are the very people who were already unburdening the public purse by paying for education privately. And then we also say that, just as in NKM, the state has not given parents schools time to adjust. That's by ground 2. Ground 3 looks at the international treaties in order to interpret the scope of Article 2 of the First Protocol and the extent of the obligations which exist on the state to give effect to the rights under Article 2 when it's properly considered. And the government has, throughout these proceedings, adopted an exceedingly restrictive scope of Article 2. They claimed below that Article 2 didn't apply to private schools at all. They denied that it included a right to found public schools, and they claimed that it would be perfectly compatible with Article 2 for the state to close all private education down entirely. And these were not positions which the divisional court accepted, but the divisional court did agree that the state discharges its duties with respect to Article 2 merely by making pluralistic free education available to all children, and that Article 2 does not guarantee rights of access to private schools. We say this is wrong, and the authorities we'll look at will show that. They also said there was no obligation to facilitate parents, at least there wasn't an obligation recognized to facilitate parents in accessing private educational choices which aren't available from the state. And it was clearly accepted that it was acceptable through taxation to hinder access to private education. And we say that when we look at the international human rights conventions, which we're obliged to in order to understand the scope of Article 2, we'll see that those were incorrect findings. The starting point of this analysis is the Grand Chamber decision in Catan against Moldova and Russia, which is at tab 54, page 1650 of the authorities bundle. And this case concerned the provision of schooling in a territory which had declared independence from Moldova and was seeking the support of Russia. And whilst it remained under the legal possession of Moldova, it was under the de facto control of Russia. And schools got caught, would seem in the literal crossfire. And the question was who was responsible for the children suffering as they had, and whether in fact the problems they were having to access education that they wanted, education taught with the Roman, with the Latin alphabet, was the responsibility of Moldova and Russia. But we don't need to enter into the details of the case. But what's significant is the extensive use the court made of international human rights instruments to determine the scope of a state's positive and negative obligations with respect to Article 2. And it's paragraph 136 on page 1693, which sets this out very clearly. And the conventions that we rely on are all cited there as ones which the court needs to take into account in determining what Article 2 says. And just whilst we have Catan open and anticipating the ground 4, want to look at paragraphs 137, 138, and 139, which are important to the submissions we're making now and we'll be making in ground 4. 137 says, by binding themselves in the first sentence of Article 2 of Protocol number 1, not to deny the right to education, first sentence, that is, the contracting states guarantee to anyone within their jurisdiction a right of access to educational institutions existing at a given time. This right of access constitutes only a part of the right to education set out in the first sentence. Then at 138, second sentence, says parents are primarily responsible for the education and teaching of their children, and they may therefore require the state to respect their religious and philosophical convictions. And what respect involves, we're going to see when we look at the case of Campbell and Cossins against the United Kingdom in ground 5, because respect imposes obligations on the state. It isn't simply they can offer free pluralistic education to everyone. And then 139, we see that the rights set out in Article 2 apply with respect to both state and private institutions. The significance of the treaties is that they impose substantial obligations on the state vis-à-vis the provision of education. They expressly apply to private education, and they go well beyond the minimalist interpretation of Article 2 adopted by the divisional court and by the government. And we say that when you look at the treaties that Catan has expressly mentioned, I'll make reference to the articles we rely on, we see that the following principles emerge. Firstly, that the duty and right to educate children is primarily responsibility of parents who can determine the manner in which education is provided to their children. So it's not for the state to say we're shutting all the private schools down and imposing our own standards that everyone's going to have to accept. It's the parents who make the decision as to how their children are going to be educated. Secondly, that states are to facilitate parents in providing education to their children in the manner the parents desire. And thirdly, we would also see from the treaties that the states are to encourage the flourishing of private education. And we say that the VAT measure achieves none of these objectives. It's not helping parents to access education that they desire for their children. And it's far from encouraging the flourishing of private education. It's causing schools to close. And that's, the government accepts that's what's going to happen as a result of this measure. We saw from the evidence in Julie Robinson's third witness statement that 106 schools, ISC schools, closed last year, and that's more than they would have expected. Before turning to the treaties themselves, I'd like to look at the case of Christian Institute and the Lord Advocate, which is at tab 28, page 565. And the passages I'd like the court to look at as paragraphs 72 and 73, statements of principle on page 590 to 591. If I could just, given our time constraints, just read some parts of these passages, so they're all relevant and useful to our case. But we start off at 72. As is well known, it is proper to look to international instruments such as the UN Convention on the Rights of the Child as aids to the interpretation of the EHCR. The preamble to the UNCRC states, the family as the fundamental group of society and the natural environment for the growth and well-being of all its members, and particularly children, should be afforded the necessary protection and assistance so that it can fully assume its responsibilities within the community. And then if we look right at the end of that paragraph, we see Articles 27.3 and 18.2 make it clear that the state's role is to assist the parents in carrying out their responsibilities. Although Article 19.1 requires the state also to take appropriate measures to protect the child from all forms of abuse or neglect. So one way the state does assist parents to ensure that children are educated, and this, in this historic moment of times for the majority of families, is to provide free education. That's one way that the state assists. But another way that the state assists is by helping parents who don't want to avail themselves of state education to access private education. And by imposing educational taxes, that the state isn't fulfilling its obligation to assist. And if we look at the last two paragraphs of in 73, we see this. Lady Hale cites from the United States Supreme Court. The first thing that a totalitarian regime tries to do is to get at the children, to distance them from the subversive varied influences of their families and indoctrinate them in their ruler's view of the world. Within limits, families must be left to bring up their children in their own way. As Justice McReynolds, delivering the opinion of the Supreme Court of the United States, famously put it in Peirce and Society of Sisters, the fundamental theory of liberty upon which all governments in this union repose excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only. The child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations. And we say that's an accurate reflection of the treaty's provisions, which we will now look at briefly. The first is the Convention on the Rights of the Child, Article 28b, which is at page 97 of the authorities bundle. And there we see that one of the obligations of the state is to encourage the development of different forms of secondary education, including general and vocational education, make them available and accessible to every child, and take appropriate measures such as the introduction of free education and offering financial assistance in case of need. So clearly the encouragement of the development of different forms of secondary education includes private education, since the free education is something additional. And the state also has an obligation to help ensure access to that form of education. Then the International Covenant on Economic, Social and Cultural Rights, tab 14, page 95, Article 13.3, state parties to the present covenant undertake to have respect for the liberty of parents and, when applicable, legal guardians to choose for their children's schools other than those established by the public authorities, and then which conform to the minimum educational standards. The Convention Against Discrimination in Education, which is at tab 13, page 91, is aimed at eliminating all discrimination in education. And Article 1 defines discrimination very broadly, including any limitation based on characteristics which include religion or economic condition, and which deprive any person or group of persons access to education of any type or at any level, or limits any person or group of persons to education of an inferior standard. Now, the divisional court found that there was discrimination, but said that this was proportionate and legitimate. But if we look at what Article 3 of the Convention Against Discrimination in Education says, is that in order to eliminate and prevent discrimination from the meaning of the Convention, the states parties thereto undertake to abrogate any statutory provisions and any administrative instructions, and to discontinue any administrative practices which involve discrimination in education. And so we say that if there is discrimination, and the court found there was, then the obligation is not on, it's not for the court to try and justify it. It's rather for the state to abrogate the cause of that discrimination. And that's what should have been happening here. We say the practical effect of the education tax measures are not to help parents access educational choices they wish for their children, but they rather make those choices unattainable for an ever-increasing number. The tax measure is going to make an increasing number of parents dependent on the state to provide education, with the grave threat to liberty that this entails, as identified by the Supreme Court in the Christian Institute case. And far from promoting the flourishing of all forms of schools, it is leading to substantial school closures. So we say that when taken read when Article 2 is read in the light of the international human rights instruments, which Catan says we have to do to understand its scope, then what we see is that it has a broad scope, and it's not one which is compatible with the VAT measure. This ground 3 feeds into ground 4, which is the essence of the right ground, which was the principal ground relied on by the Claim 1 claimants in the court below, and it's one we gratefully adopted and we adopt now. This ground argues that the VAT measure is unlawful because it directly impairs a central right protected by Article 2 of the First Protocol. And in the Belgian linguistics case, the Strasbourg court established the principle that regulation of education cannot injure the substance of the right itself. And we'll find this at tab 38, page 1184. Now that case hasn't got convenient paragraph numbers, but there's a number 5 right at the bottom of the page, and that's where we need to read. The right to education guaranteed by the first sentence of Article 2 of the Protocol, by its very nature, calls for regulation by the state. Regulation which may vary in time and place according to the needs and resources of the community and of individuals. It goes without saying that such regulation cannot injure the substance of the the right to education, nor conflict with other rights enshrined in the Convention. If we go back and we look above where this passage started, so page 1184, where there's the number 4, we see there that the right of access to education is expressly described. So this is, we say this is the principal right that's been identified. The first sentence of Article 2 of the Protocol consequently guarantees, in the first place, a right of access to educational institutions existing at a given time. But such access constitutes only a part of the right to education. And this was the same right which was repeated and identified in Catan, which we just had a look at, where we also saw that these rights apply to private educational institutions. The principle of non-impairment of the substance or essence of the right has since been applied in relation to other convention rights, and the court has repeatedly affirmed that measures which impair the essence of a right are not permissible. And this principle, if one looks at the Strasbourg jurisprudence, goes both to the legitimacy and to the proportionality of the measure. We say where a measure directly itself undermines a right, then this goes to the legitimacy of the measure. Where the practical consequences of a measure render a right ineffective or illusory for an individual or a class of individuals, then it also goes to its proportionality. But it's rendered illegitimate as well. We'll have a look at some cases which deal with this in a moment. But the next case I'd like to turn to, which deals with this right of access to education, is the case of Shaheen against Turkey, which is tab 48, page 1410 of the authorities bundle. And Shaheen concerned a woman denied access to the University of Istanbul because she wore a headscarf. And so one of the questions in that case that the Grand Chamber had to determine was whether Article 2 of the First Protocol extended to universities or not. And it used the living instrument doctrine to make a finding that it did. And we can see that at paragraph 36, page 1443. Moreover, conventions are living instruments which must be interpreted in the light of present-day conditions. While the first sentence of Article 2 essentially establishes access to primary and secondary education, there is no watertight division separating higher education from other forms of education. And Shaheen then emphasizes the fundamental role education plays in a democracy and the extent to which it must be protected, and therefore we say the broad scope that it should be recognized to have. And we can see this in paragraph 37, page 1443. Paragraph 137. I'm sorry.
Yeah.
You're at page 1443, and I think you want paragraph 137.
Yes. And it's the last paragraph there.
Which says that a restrictive interpretation would not be consistent with the aim or purpose of the provision.
Yes, says it's such a fundamental role in democracy that we're not to the restrictive interpretation will not be consistent. Now, if we then look at what the divisional court found, and this we say was incorrect finding, this was a conclusion at page paragraph 253. They say, the analysis we have set out earlier in this judgment shows that the substantive rights guaranteed by Article 2 go no further than the right of access to whatever educational system the state chooses to provide. And then they recognise a right to establish a private school, which the government had been denying, but there were a number of authorities which expressly said there was such a right. So they couldn't deny there was a right to establish the private school, but that's as far as they went. If we look instead at paragraph 141 of Shaheen on page 1444, we see this. It is clear that any institutions of higher education existing at a given time come within the scope of the first sentence of Article 2, Protocol 1, since right of access to such institutions is an inherent part of the right set out in that provision. So we say that the Divisional Court erroneously adopted a restrictive interpretation of Article 2, which restricted the right of access only to schools the state chooses to provide. And that's not what Strasbourg Court said. It said it applies to any institutions. In that case, higher education. But obviously, since it was a dispute in Shaheen whether Article 2 even applied to institutions of higher education, we say A40 all right. It also applies to other schools. It's a right of access. And it's that right of access which is impaired by the education tax which the government has imposed. If we look at the domestic case of SAE Education Limited and the Revenue and Customs Commissioners, tab 30, page 654, case starts, and I take the court to paragraph 43 on page 666, where Lord Kitchen recognised that the purpose of a VAT exemption, and this is under the directive, for educational provision is to ensure that access to education is not hindered by higher costs. He says the general objective of the exemptions in Articles 133 to 135 is, I think, readily apparent. And so far as university education is concerned, it is to ensure that access to the higher educational services this necessarily involves is not hindered by the increased cost that would result if those services were subject to VAT. So a recognition by the courts that the imposition of VAT is going to hinder access to education. And that's the impairment that we say that the education tax, the VAT measure, has on the right of access to the schools. And that's why it does injure the very essence or substance of the right. And so the situation we now have as a result of the measure is that access of parents to the schooling that exists in the state and which they require for their children, in this case on account of their religious beliefs, becomes conditional on them paying substantial sums to the state. And so the very provision of the service to which the appellant parents and children have a right of access is being taxed and being impaired. We say this is to be distinguished from neutral regulations which do not directly tax education, though they may have an indirect effect of making education more expensive. An example that was considered, for example, of fire regulation, which is imposed on all schools, and it will have costs to comply with, but it's not a tax on education. And that's the difference. And the analogy was made in the divisional court with a mass tax imposed on Catholics who wish to attend worship in their churches. And the divisional court, at paragraph 64, said that they didn't find this analogy very helpful, and they dismissed it for three reasons. They said, first of all, the state provides a free alternative to the private schools, so people's rights aren't interfered with, then they say that private schools are already inaccessible to the vast majority, so putting a tax on this doesn't change that matter. And thirdly, they say that the Strasbourg case of Klein against Germany accepted that it was compatible with Article 9 to tax religion, so therefore the analogy didn't go anywhere. And we answer these objections in our skeleton, but it's an important analogy, and we say it's very apt, and I deal with them here as well. Plus, it is no answer that there are free alternative schools. The protected rights under the first sentence of Article 2 is the right to access any educational institutions which exist at a given time. And under the second sentence of Article 2, the right of parents to choose the type of education they wish for their children. The provision of a free state alternative is entirely beside the point as far as the right of access or the right of choice is concerned. And we say it simply wouldn't be an answer if the government was to try and defend the mass tax for the state to say to those Catholics who don't want to pay the tax or can't pay the tax, well look, there's no interference with your Article 9 rights because the state provides free, pluralistic, syncretistic worship services in state temples. That's not an answer. The fact that a section of the public cannot in practice afford privately to educate their children does not mean that it is therefore lawful for the state to impede access to those who can afford the fees or who make sacrifices in order to afford the fees. And the point can also be made that access, the fact that state-funded schools or universities may select on the basis of academic ability does not mean that the state is failing to guarantee a right of access, because the majority of the population might thereby be excluded because they don't reach those standards. What's important is that the state does not erect its own obstacles to access. And we, in footnote 2, in our skeleton, we mentioned the case. It's not in the authorities bundle because it was there's no principle in dispute there, but it's important, makes an important point. And it's the Supreme Court case in Nuffield Health and Merton London Borough Council, which was a challenge to a private health provider and whether someone who charged for access to the health benefits could satisfy the public interest requirements, or whether they couldn't, because not everyone could access them, because not everyone could afford them. And the Supreme Court was clear that they did satisfy these requirements, because it's not, access isn't prohibited to anyone, it's open to anyone. It's just a fee is charged to people, in that case, to access those services. Finally, the case of Klein against Germany, which is at tab 57, page 1812, we say was incorrectly considered by the divisional court. Klein was a case which involved an unsuccessful challenge to a church tax imposed by the state in Germany. But the important point that wasn't appreciated by the divisional court is that this tax was imposed precisely with the agreement of the church itself. It's not the case of a tax imposed by the state contrary to the wishes of the church, and where the money raised does not help the church at all. And we can see that in paragraph 9, page 1814. The second sentence there, the churches decide independently whether to levy a tax and what its rate should be. So if a church decides that there's going to be a fee to attend its services, then that's fine. It's the decision they've made. But in this case, the fee is imposed by the state, and it's contrary to the wishes and interests of the schools, and contrary to those of the parents. And also notable that in Klein, the money, a large chunk of the money, was retained by the church, and in this case, it's not going to the schools, it's going elsewhere. Wanted very briefly to look at, to conclude this ground, looking at the proportionality. I mentioned at the outset that the essence of the right could be interfered with either if the right itself is undermined or if the practical effects of the right are undermined. And I'd like to look at the case of, well, I mentioned in our skeleton at paragraph 54 the case of Nalbant and Turkey. Again, it's not in the authorities bundle, but we cite paragraph 36 there, which is important. It says, to illustrate how the court applies this principle. Furthermore, the court has considered it excessive and therefore an impairment of the very essence of the right of access to a court, where high court fees were not justified by the applicant's financial situation, but were instead calculated on the basis of a set statutory percentage of the sum at stake in the proceedings. And a case which expands upon this principle is Julian against Estonia, which is at paragraph 54, tab 52, page 1538 of the authorities bundle. And this was a case of a prisoner who wished to challenge his conditions of detention. And one of the grounds of complaint is that he did not have the money to pay the court fees, and so was denied access to justice. And then we see at paragraphs 160 and 161 on page 1574, turning to the present case, the court has no reason to question the legitimate aim of the requirement to pay the state fees in question. Such fees can be seen as contributing to the financing of the judicial system, as well as securing its proper functioning by limiting the number of meritorious complaints. The court notes that the fees the applicant was required to pay, the equivalent of €64, do not seem high in themselves. These sums represent about a quarter of the national minimum monthly salary at the material time. Nevertheless, the court has to examine the applicant's actual ability to pay these sums in the particular circumstances of the case, as well as his chances of obtaining exemption from these fees in order to assess whether they effectively prevented the applicant from exercising his right of access to the court. And then at 178, page 1578, the court considers that such a restriction on the right of access to the court was disproportionate and impaired the very essence of that right. Accordingly, there's been a violation of Article 6.1 of the Convention. Again, the government claims that the provision of free education is an answer to this point. But again, the reply is that the free education provided by the state is unacceptable to the parents. And whilst no one is obliged to bring legal proceedings in the courts, parents are obliged by law to educate their children. So if anything, we say the interference with the essence of the right is even more serious here than in the court fee cases. We'll be looking again at the cases when we consider proportionality of Nalbant, Julian, and Unison. But the important point was that in those cases, that the right to access the court was impeded because there was no mechanism which existed to accommodate individuals who found themselves financially unable to exercise their rights. And we say that the VAT measure similarly fails to make any provision for exemptions or for any individual assessment of circumstances, and so fails to be compatible with the proportionality requirements of Article 1, even if we fail on our primary ground, which educational taxes in themselves are unacceptable because they interfere with the essence of the right. Ground 5 will be taken quite briefly, since the underlying argument relies on only one authority, and that's the case of Campbell and Gossens against the United Kingdom, which is at tab 41, page 1275 of the authorities bundle, and we set out the argument in our skeleton. We say that the divisional court did not properly consider this argument, despite it being clearly set out as a separate ground of challenge, because it wrongly treated it as part of a discrimination claim pursued by all three groups of claimants under the second sentence of Article 2 of the First Protocol. And this instead is a claim made under the first sentence of Article 2. We've seen that in Article 2 of the First Protocol, it protects the second sentence, protects the rights of parents to access education that they desire for their children. But the first sentence protects the child's right to education. Interlinked, but they're separate rights nonetheless. And the court in Campbell and Cossins treated them separately and came to different conclusions on the rights. What we say is that the VAT measure interferes with the rights of children whose parents, like the appellant parents in the present case, are not prepared to send them to state schools for reasons of religious conscience, and who, if they're not able to afford private fees as a result of the government's education taxes, will no longer have educational choices for their children. The case of Campbell and Cossins, in that case, the parents had a philosophical objection to the provision of corporal punishment. And one of the children, Geoffrey Cossins, had misbehaved and was due to be administered corporal punishment, and the parents removed him from the school. And he was suspended, and then the school said, well, you've had punishment enough. And the parents said, well, we're not sending him back unless we have a guarantee that he's not going to be subject to punishment in the future. The school said, no, we can't give you that guarantee. So the parents kept him away from the school as a result. And this was deemed by the European Court to breach the rights of the child. It breached the rights of the parents under the second sentence of Article 2 of the First Protocol, but it also breached Geoffrey Cossins' rights under the first sentence, independently of the parental rights, because the parents were not able to secure an education for their son which was free of corporal punishment. It's important, the court didn't rule in that case that corporal punishment was contrary to human rights. The issue was whether the state was obliged to accommodate parents who objected to corporal punishment. And the accommodation in that case could have been to have permitted effective rights of excusal from the corporal punishment regime. We say in the present case, the only accommodation we seek is a non-interference with the right of access to the schools, which the imposition of the VAT measure instead risks denying. In Campbell and Cossins, the non-existence of an excusal regime led to Geoffrey being denied an education. In the present case, we say the government's new education taxes risk leading similarly to the appellate children being denied an education. And this is an important point. The same issue, if we look at the case, was raised there. Well, you've got a legal obligation to educate your child. So if you don't turn up to school, you could be prosecuted. And the government makes this point here as well. But that wasn't a defence that exonerated the UK in that case. And nor was it the case that, well, the parents could have homeschooled him. Or they could have gone to a private school. That wasn't the point. The point is there wasn't an accommodation of parental requirements, and that failure of accommodation, risking the education of the child, led to a breach of the first sentence of Article 2. But central to this whole issue is the question of respect, which we looked at before. And we can see the discussion of this on page 1287, paragraph 37A, bottom page. The court said, the court is unable to accept these submissions. Whilst the adoption of the policy, and the submissions were, well, we're in the process of abolishing corporal punishment. Whilst the adoption of the policy referred to clearly foreshadows a move in the direction of the position taken by the applicants, it does not amount to respect for their convictions, as is confirmed by the fact that, in the course of the drafting of Article 2, the words have regard to were replaced by the word respect. The latter word means more than acknowledge or take into account. In addition to a primarily negative undertaking, it implies some positive obligation on the part of the state. This being so, the duty to respect parental convictions in this sphere cannot be overridden by the alleged necessity of striking a balance between the conflicting views involved. And here the claimants, the appellants are not claiming that there is a positive duty to subsidize the evangelical Christian schools. But what we are saying in this case, that what respect requires, is that, that taxes which have been found, which the court below found to have been discriminatory, are removed. And the state, we say, has a negative obligation not to impose those taxes. This is the minimal obligation that in this case respect entails. The courts accepted that there's a right to found a public school, but we say that the minimal accommodation is one of the state not impeding access to education that the parents wish for.
Can I just ask you again, how broad is that submission? Is it confined to these appellants, or does it apply to all parents, or all parents who can't otherwise afford a private school?
This submission is narrower than the others. It would apply, first of all, to parents who are not willing to accept state education, the reasons that these appellants have explained. And there may be...
When you say not prepared to accept, do you mean for some because of a belief system?
Yes. And secondly, because there may be some parents, and we've got various surveys that I don't have the references to them here, but we have various surveys that some of the schools conducted, saying, look, we may need to close, and they asked the parents, the appellant schools in this case, what will you do? And some of the parents said, well, we'll go to the state school. Obviously, this submission wouldn't cover them because their children are not going to be denied an education. But other parents have said, we're going to have to homeschool. And we say in that case they would be denied an education. And other parents have said, we don't know what we're going to do because we can't homeschool, we haven't got the time. And, or in cases, and it's explained in the case of two of the appellant parents, the difficulties with when you have children with certain educational needs or disabilities, where the role between a parent and teacher has to be divided. You can't educate those children as a parent at home. And those parents saying, look, we don't know, we have a religious objection to the child going to the state school. We're not able to educate the child at home. We don't know what we're going to do. And so that we'd say in those circumstances, it would apply. Now, obviously, we're not saying the state has to subsidise or to pay for those payments. We're simply asking that the state not interfere with what the parents wish for. And what we should also
How do you decide which parents are governed by this breach of A2P1? I mean, is it all parents because they haven't decided what they're going to do, all parents in all private schools because they haven't decided what they're going to do yet, or they may take time to decide, or is it just parents who have expressed a view that they would not accept state education?
Well, it would certainly apply to a parent who wasn't able to pay fees and had withdrawn the child from school and wasn't able to provide homeschooling. That isn't the case, I hasten to add, with any of the appellants at the moment. So in a way, what we're saying, we're not in the position of Jeffrey Cossens. At the moment, there is an education, but there's a very grave risk that there won't be. And that's the what this ground is aimed at addressing. We can't wait until the risk is materialized. But the importance of this ground is, and I appreciate that none of the appellant children are yet directly suffering because they're continuing their education. But the importance of this ground is to focus attention on the state's obligation to respect and what that requires in the context of Article 2. And it's simply not satisfied by the government saying, well, we provide pluralistic education suitable for all children. That's not respecting the parents' rights to access education that they desire. So in a way, it buttresses the previous ground. Ground 6 is on the margin of appreciation, and we say, again, the divisional court has fallen into error. And the first one has fallen into error, and it deals with this at paragraphs 91 to 95 of their judgment, which I'd ask the court to turn to. We can see the problem that it fell into. And the problem is that it restricted the application of the doctrine of margin of appreciation and convergence of state practice to questions of morality alone. So that if convergence of state practice is not due to a common moral practice, then the margin of appreciation doctrine, the divisional court says, does not apply. You can see this very clearly and repeated in those paragraphs. So, and the reason they made, these were the government submissions below, which presumably were adopted by the divisional court. Now, the government has modified their submissions. They now say that it's not just moral matters, but also human rights matters, which might engage the margin of appreciation. But if they'd said that below, and if the divisional court had said that, then there wouldn't be a problem, because of course human rights are implicated here. But the issue below was, look, taxing education is simply nothing to do with morality, therefore the margin of appreciation doctrine doesn't apply. I can just take you through those paragraphs. 91, second sentence. Moral standards develop over time. Where there is a significant disagreement between contracting states about such standards, it is unlikely to be appropriate for a supranational court to impose its views. Where, however, there is a consensus among other contracting states on a moral issue, judgments informed by that consensus can be more easily accepted as illegitimate by an outlier state with the self-awareness to recognise that it may have something to learn from the combined wisdom of its neighbours. Then on to paragraph 92. Convergence in state practice is not, however, always attributable to a common moral position. It may emerge for other reasons. If a state decided in its own interest to take a different position, there would be no reason to regard the common practice of other states as material to the breadth of the margin of appreciation. The Convention does not promote uniformity for its own sake, nor does it set its face against novel approaches to political questions. Then in 93, we see that again. In the present case, the common practice of other states does not seem to us to imply any common moral view that there should be no VAT or other similar tax on the fees paid for private schools. And then at the end of that paragraph, there is nothing to suggest that they consider themselves constrained in this respect by the Convention or any moral standard reflected in it. And the second error is that they said, well, since the VAT directive did not reflect the moral position, so the consensus that it reflects does not impact one way or the other on the breadth of the margin of appreciation. And that's in 95, second sentence. There is no dispute that the services provided by private schools do serve the public interest. The question is whether the mandatory requirement to exempt them from VAT reflects a common moral position that they should be so exempted. When the scheme of the directive is considered as a whole, we find it hard to accept that it reflects such a moral position. I would like like to take the court to two authorities to show that
just
this...
before you, forgive me, just
Yes.
before you do, if suppose you're right that the use of the word moral in this context was inappropriate, where does that get the legal submission? Isn't what's going on here, but please correct me if I'm wrong, is that what the court is trying to do is to interpret the scope of the ECHR, and in particular A2P1. And so, don't you have to establish that whether one calls it a moral consensus or some other consensus, that the state practice around the Council of Europe is such that it delimits the scope of A2P1? Because otherwise, where is this legal submission going?
Well, the legal submission's going here. It's that we'll be looking at a couple of authorities. But the legal submission is that we have not a general consensus. We have, with the exception of the United Kingdom, a universal consensus, and it's not just in European Union, but it's across the whole of the Council of Europe.
Yes, I know.
And in the face of that consensus, we say that the term morality could be used in a broad way. Talk about the mores, the practices of the nations, and in that respect, there is a consensus. And so, if the divisional court was restricting the term morality only to mean controversial ethical questions, which is clearly what it was doing there, we submit, then that's wrong. If it instead was looking at the broader use of consensus, then it was wrong to exclude it, because there is a consensus, and that does inform the court's approach to whether the doctrine of the marginal appreciation is relevant at all. The marginal appreciation doctrine arises when, in the face of an interference with a human right, the court is called upon to look at the legitimate aim that the Convention article is pursuing. And so the correct question here, in front of an interference with the Convention rights, the question the court has to ask is it necessary in a democratic society for the United Kingdom to tax education? We say that's the question. And the answer to that question, in the face of a universal consensus that it isn't necessary,
Yes.
and in fact which goes further than that, which laws have been put in place, like the VAT directive, which we say solemnize the recognition that that taxing education is wrong, then there isn't any marginal appreciation. And the court simply will say, no, it's not necessary in a democratic society to tax education. Every single other country manages to do without it. And the outlier state is the United Kingdom.
And that argument, if it's a sound one, does not turn in any way, does it, on who your clients are, who your clients' schools are, their religious convictions. That would apply to all parents sending their children to any private school in this country. Is that right?
Yes, it is. And we're taking a principled position, and we're simply saying that taxes on education are not compatible with Article 2 of the First Protocol. If we need to adopt a narrow position, then we will also adopt the low-cost threshold schools which are educating it below the government cost of educating pupils, and we'll have something to say about that tomorrow when I deal with Ground 8. But just to make good the submission, I'd like to take that the concept of morality is far too narrow in any case, and that the marginal appreciation doctrine applies in all sorts of other cases where there's a consensus or not. I'd like to look at the Grand Chamber decision in the case of Lautzi against Italy, which is at tab 51, page 1494 of the authorities bundle. And this was a challenge to the presence of crucifixes on the walls of schools. And this was held by the court, not the Grand Chamber. The court held it to constitute unlawful indoctrination. And the case was then referred to the Grand Chamber, which in a split decision held that since the crucifixes were only passively present, this did not amount to indoctrination. But it just shows how little a school has to do, potentially, to cross over into the indoctrination threshold. And it supports my interpretation of JR 87 and why the sort of schooling that the Appellant schools are providing simply would not be permissible to be funded by, to be provided by the state. The presence of crucifixes on school walls, we say, is not a matter of morality, however widely one wishes to use the term, but nonetheless the Grand Chamber found that the margin of appreciation doctrine did apply, and there it was invoked to protect traditions. And we see this at paragraph 67, page 1520. The Italian government said that the presence of crucifixes on school walls is a tradition which it considers important to perpetuate. And then the Grand Chamber at paragraph 68 of the same page says, the court takes the view that the decision whether or not to perpetuate a tradition falls in principle within the margin of appreciation of the respondent state. The court must, moreover, take into account the fact that Europe is marked by great diversity between the states, of which it is composed, particularly in the sphere of cultural and historical development. It emphasised, however, that the reference to a tradition cannot relieve a contracting state of its obligation to respect the rights and freedoms enshrined in the Convention and its protocols. And while we are with Lao Tzu, if I could ask the court to turn to paragraph 59, page 1517, and this is relevant to the next ground, but since we're here, we might as well deal with the point now. And this is the government's claim that we make the point in the next ground that Article 9 claims don't require group disadvantage. And we cite some authorities for that. And the government says, well, look, this isn't an Article 9 claim anyway. But Lao Tzu at paragraph 59 says this: the court reiterates that in the area of education and teaching, Article 2 of Protocol number 1 is in principle the lex specialis in relation to Article 9 of the Convention. That is so at least where, as in the present case, the dispute concerns the obligation laid on the contracting states by the second sentence of Article 2 to respect the rights of parents to ensure teaching in conformity with their own religious and philosophical convictions. So the same principles, we say, clearly apply to Article 2 of the first protocol as apply to Article 9. But that's anticipating the next round. The second case on margin of appreciation, which I wanted to take the court to, was Klein against Germany, which we looked at before in relation to church taxes. But it's also useful, has something useful to say on the margin of appreciation. If we look at paragraph 87 on page 1827, we see this. In delimiting the extent of the margin of appreciation, particularly as regards the building of the fragile relations that exist between the state and religions, the court reiterates that there is no common European standard governing the financing of churches or religions, such questions being closely related to the history and traditions of each country. And there again, we see that the margin of appreciation doctrine in that case that found that the state could take a different position because there wasn't any consensus, but it was a position on a matter which had nothing to do with morality. It was a tradition again, the financing of churches. We could just briefly look at the VAT directive, which is at tab 16, page 98. obviously, the United Kingdom is no longer part of the European Union, but it had signed up to this at one point, and the provisions of this directive bind everyone else. And the directive has a whole imposes an exemption on the application of VAT, and VAT was introduced by the European Union in order to harmonise the market. That's accepted, but at the same time there was concern that activities in the public interest shouldn't be subject to VAT. So we have a whole lot of activities there: medical activities, supply of human organs, blood and milk, dental technicians, activities which are largely governed by charity law in the United Kingdom. But then we also see that the supply of, we see that tuition in I and J, well, it's private tuition in J, I, the tuition at school, university, young people's schooling, vocational training, and all the goods and services closely related. And that's the point we're going to get to in the next round we're going to look at. But they're all exempted in the public interest. The Divisional Court said, well, if we look at Article 135, then we'll see that there are all sorts of other provisions which obviously have nothing, which are also exempted. And so there are insurance and reinsurance and betting and other things which are also exempted. And therefore the Divisional Court says this says nothing about the provision of education. But we say it is significant that the exemptions in education are in a different chapter, and it's one expressly headed exemptions for certain activities in the public interest, whereas those on insurance is just simply for other activities. And then it's no part of this case, and I hesitate to make any submission, but on that, but there may well be very good reasons why, in order to facilitate a single market, it was necessary to exempt other activities. But we say that this doesn't apply to the case of education. There may be cases on the periphery when, for a limited number of students, parents are considering which country to send their children to school. But certainly for the parents.
So when we left the EU, presumably there were domestic provisions that reflected the directive. Were they amended?
Well, not as regards education, and I can't say on anything else. The point is that the public interest exemptions, which are contained in Article 132, largely relate to exemptions which exist in this country for charitable activities generally. And in fact, the public schools find themselves in I believe, in a unique situation now, in that these private schools are charities, but they're taxed on the public benefit services they provide. I don't believe that other charities are subject to this detriment. So we kept in place all our charity law. It's the point that I was drawing from this. And it just is not relevant to look at other articles of the convention, say, well, there we go. Because Article 135 has got matters relating to single market, therefore that shows that 132 must also be part of that. VAT was imposed on all European member states as a common tax, and it was necessary to carve out an exemption for public interest activities, and that's why they were carved out. And we say that recognition of that necessity was one which preceded the VAT directive. It was one which the consensus had coalesced around the principle that education was not to be taxed. It was such an important right in a democracy, and the international human rights instruments, which we saw necessitate that states encourage its flourishing, that this would go contrary to all those obligations if introducing VAT was then schools were suddenly subject to it. And repeating a submission slightly different, taking a slightly different angle, but we look on proportionality, just make a final observation, even where there's no universal consensus, and that was the case in the matter of prisoner voting in Hearst, where we saw that there were 13 states at least, other than the United Kingdom, who had laws which were even more restrictive on, equally or even more restrictive than the United Kingdom. But the state will exceed its margin of appreciation where it lays down absolute laws which do not allow the possibility of exception. And if we do need to get to proportionality, then we say that's precisely the situation we have here, where the VAT measure, again, does not allow the possibility of exemptions to ensure the parental Article 2 Protocol 1 rights are respected. That takes me to the final ground I'm dealing with today, which is ground 7 on discrimination. The Divisional Court was prepared to accept, at least for the sake of argument, that the imposition of VAT on school fees did constitute discrimination towards a subgroup of evangelical Christians, which include the apparent parents. But they say that such discrimination was justified when it came to the proportionality valuation. That's paragraphs 175 and 176 of the judgment. Our primary submission is that once we've established discrimination, we say we don't get into proportionality assessments, and that the measure should fall for that reason. And looking again at the passage that my learned friend took the court to before, but a different emphasis in Guberina in a moment.
So the entire measure falls on this ground?
If discrimination is established, yes.
So the entire measure falls on the basis that it discriminates against evangelical Christians?
Well, it also discriminates against the difficulty with the measure is that it either stands or falls. It's not that it's got different sections in it that would satisfy the evangelical Christians but leave the rest of the measure intact. We say that the discriminatory measure will be incompatible.
I mean, your ground of appeal says that the Strasbourg authorities prohibit discriminatory tax schemes, and this is one, so it fails altogether.
Yes. I mean, one of the groups being discriminated against is, and independently of religious considerations, we say that private schools, and we'll get to that argument in this ground. But even if we're wrong, then we say that for proportionality reasons, the discrimination shouldn't be applicable. The Divisional Court and the government argue, well, the government argues in its respondent's notice that the evangelical Christian claimants, have not substantiated the group disadvantage, and therefore we can't make good any claim for indirect discrimination or limnos discrimination. So I want to deal with that argument first. And that argument was, as I indicated when we looked at Lao Tzu in the previous ground, is that in fact Article 9 doesn't have a group disadvantage requirement at all. And I make no claim about any other convention articles, but certainly as far as Article 9 is concerned, there's no group disadvantage.
But this is not an Article 9 case.
Well, it is. It's an Article 2 of the First Protocol case, which is the lex specialis of Article 9. And this is a case which...
Which is what?
It's the particular law for Article 9 in the field of education. As the case of Lautsi, I took the court to the passage in Lautsi before, which shows that that's what the court said. So if you're... There may be separate Article 9 arguments that one could raise in the context of education, but if you are to raise an Article 9 point, if you're in the field of education, that's how Article 9 is to be considered. It was paragraph 59 of Lautsi, page 1517.
I understood that submission when you made it in the context of A2P1. I understand. And you said that's the lex specialis, and Article 9 doesn't specifically need to be pleaded. But under ground 7, which you're now on, it's headed discrimination. So this is an Article 14 complaint.
Yes.
Is it? Yeah, right. Now, under Article 14, is the respondent not correct to submit that you either have to show, well, you have to show one of three things. One, direct discrimination, you're not relying on that. Or you have to show liminos discrimination or indirect discrimination. And for those two grounds, they submit that you do have to establish on evidence that there is a disproportionate disadvantage to a particular group, because otherwise you don't have an Article 14 complaint. You may have other complaints, you don't have an Article 14 complaint. That's what they're saying.
The complaints overlap to an extent, in as much as a complaint under Article 9 can also constitute discrimination. And one of the cases I want to take the court to, and it was a case that my Lord Master of Rolls was involved in, is a case called Mabar.
13 years ago.
But before looking at Mabar, I just wanted to mention the case of Williamson and the Secretary of State for Education, which is at tab 20246. Perhaps I don't need to take, I set out the paragraph we rely upon in our skeleton argument, but this was a challenge to the law banning corporal punishment in private schools. And maybe it was the early days of the Human Rights Act, and maybe the approach wasn't as precise as it would be today, but it was brought under Article 9. But it was clearly an indirect discrimination challenge. There was a law which was neutral on its face, which prohibited corporal punishment in schools, and a group of schools who thought that whose religion they said required them to have the possibility of corporal punishment challenged that measure. So it was an indirect discrimination claim, and it was brought under Article 9. And in that case, Lord Nichols, in the passage I cited, just makes the important point that that freedom of religion protects the subjective belief of an individual. And so you can't have a protection of Article 9 unless you also are protecting even idiosyncratic beliefs. And in Mabar and Merton London Borough Council, tab 25439, this was a case which concerned whether a local authority had the obligation to accommodate an employee who, for religious reasons, did not want to work on Sunday. And one of the issues was whether her belief was a core component of the Christian faith, and whether there was, in fact, Article 9 contained a group disadvantage requirement. So it was a it was a case which was being run under domestic discrimination law, but which was relying upon Article 9 to inform how that discrimination law was to be interpreted. And that's why I say there's an overlap when a case like this is being run between Article 14 and Article 9, because it was a discrimination case. But the key point was to look at what Article 9 had to say. It would be very odd if Article 14 it imposed different requirements. But in that case, at paragraph 21, page 448, this is what the court said, and this is Lord Justice Morris' case summed up the position of the court. He said, Lords Justices Elias and Voss take a different view about the relevance of Article 9. This is a more sophisticated analysis. For my part, whilst I agree that Article 9 does not carry a requirement of group disadvantage, I prefer not to resort to reading down for convention reasons the domestic provision, which is compliant with the directive from which it is derived. And the problem we have, Article 14 on its face doesn't talk about group disadvantage. This is a domestic law under the Equality Act and its predecessors. We've had for indirect discrimination, a group disadvantage requirement. But the result of importing a group disadvantage requirement for an Article 14 claim related to Article 9 would in fact be to discriminate against beliefs which weren't held by a group. And there's every reason why that can't be right in the context of Article 9. And that's why I say Article 14 can't, in the context of Article 9, have a group disadvantage requirement. Otherwise, Article 14 itself would be discriminatory against idiosyncratic beliefs. And if we look at, and we're being told that Flimenos discrimination is also has a group disadvantage requirement. But if we look at the case of Flimenos and Greece at tab 45, page 1337, we don't see that at all. Mr. Flimenos was convicted for refusing to wear a military uniform during a time of general military mobilization, and he refused to do this for religious reasons. When he then tried to apply for a job to become an accountant, he wasn't able to get that job because the law prohibited anyone convicted of a crime from being appointed as an accountant. And the European Court said that the problem with this law was that it discriminated against him because the law should have treated people differently if their situation was significantly different. And Mr. Flimenos's crime didn't involve, the court said, moral turpitude, and it was wrong to have sanctioned him in the same way as people convicted of serious criminal offences. Paragraph 44 on page 1350 explains that, and it says, the court has so far considered that the right under Article 14 not to be discriminated against in the enjoyment of the rights guaranteed under the Convention is violated when states treat differently persons in analogous situations without providing an objective and reasonable justification. And there is nothing in the case of Flimenos which indicates that any sort of group disadvantage is required. The breach of Mr. Flimenos's convention rights by Greece was a result of his individual beliefs, not because he was part of a group which held similar beliefs. And so it's odd if now Flimenos discrimination, which didn't require a group disadvantage, suddenly requires it when we're invoking it in a claim like this one. And we see a similar issue. The government objects to our reliance on Carson and against the UK. In fact, we removed it from the authorities bundle and replaced it with the case of Biao against Denmark, another Grand Chamber case and a more recent one. Carson, we accept, was a direct discrimination case. And the test there is laid out about different treatment of persons in analogous or relevantly similar situations. But the case of Biao is an indirect discrimination case, and it repeats the test cited in Carson at paragraph 89, page 1770. It cites Carson. We've got the same test for indirect or direct discrimination under the convention, and again, it shouldn't surprise us because the convention, unlike the Equality Act, doesn't talk about direct and indirect discrimination. Doesn't make these distinctions.
Sorry, what is the test that you're invoking?
In order for an issue, the test in paragraph 89 is this, and it's the Carson test, which we were told didn't apply to indirect discrimination cases, is this. In order for an issue to arise under Article 14, there must be a difference in the treatment of persons in analogous or relevantly similar situations. Say that's the test. Are the people in, that's an indirect discrimination case, are they in an analogous or relevantly similar situation? And we say that they are, and we say that with regards to the parents and pupils in the appeal, that the person or persons in relevantly similar situations are those parents and pupils from a similar socioeconomic background, but who do not have the same religious or belief-based requirements with regards to education. And with regards to the schools, we say that the private charitable schools, for reasons that we're going to see in a moment, are in an analogous and relevant similar situation to other independent schools, so namely to academies and free schools. The government says they have objections to status. They say that being a private school is not a status. We say that it is a status. The status requirement is not very onerous, as we can see from SC itself. I mean, there the relevant status was being a family with 3 or more children. That was accepted to be a state status. And the court there at paragraph 71, page 795, said cases where the court has found the status requirement not to be satisfied are few and far between. That's not where the battle is on status. The point is, can the situation be described in a legally significant way? And being a private school as opposed to being a different type of independent school is capable of distinction. And the other case we'd refer to as the National Federation of Self-Employed versus United Kingdom, tab 40, and that was a case where the Commission held that being self-employed as being employed, as opposed to being employed, well, again, was a relevant status. It's not, the distinction can clearly be met, and I don't propose to say anything else about that. The issue's not about status. What we do say is that what we have in place is a discriminatory subsidy regime, and I'd like to take the court to the case of X against the United Kingdom, tab 39, page 1258. And this is a case which considered an application by a parent who wished to establish a new non-denominational school in Northern Ireland. And the complaint that the parents had was that whereas subsidies, in that case subsidies, government funds of 100% of capital expenditure and recurrent costs were available to state schools, which were formerly private Protestant and Catholic schools. Any private body wishing to set up a non-denominational school could only obtain financial aid covering 85% of capital costs while still receiving 100% of recurrent costs. And this was said to breach the Article 2 rights. And the Commission dismissed this complaint, saying that, repeating the principle which we've seen in cases from the Belgian linguistics case onwards, that there's no obligation on the state to subsidise education. So that complaint dismissed. But then what the Commission did was important for our case. It said that it decided ex officio to examine whether the difference in funding complied with Article 14 taken together with Article 2. And that can be seen at page 1259, where it says number 2. The Commission has also examined ex officio whether the difference in subsidy available to state schools on the one hand and voluntary schools on the other hand is a breach of Article 14 of the Convention, in conjunction with the second sentence of Article 2 of the first protocol. And then 3 paragraphs from the bottom of the page. Citing the Belgian linguistics case, a measure which in itself is in conformity with the requirements of the article enshrining the right or freedom in question may, however, infringe this article when read in conjunction with Article 14, for the reason that it is of a discriminatory nature. And then later, it follows, therefore, that in the present case, when it is clear that Article 2 of the first protocol does not give rise to an obligation to subsidise any particular type of education, Article 14 would require that the authorities do not discriminate in the provision of available financial subsidies. And what was important in this case is that the Commission found that there wasn't discrimination. So there was discrimination, but it was justified. There wasn't discrimination in the subsidy regime, because the difference in treatment could be justified for 2 legally relevant factual reasons. And these related to the ownership of the schools and management and control of the schools. And this is what the Commission said. It is reasonable for the state in relation to bodies that seek ownership and decisive control over management policy in voluntary schools to require some degree of financial contribution. And the same principle is in the case called Verein Gemeinschaftslernen against Austria, tab 43, page 1310. And looking at page 1313, there again we see no positive obligation on the state under Article 2 to subsidise any particular form of education. However, a measure which in itself is in conformity with the requirements of the article ensuring the right of freedom in question may infringe this article when read in conjunction with Article 14 for the reason that it is of a discriminatory nature. Accordingly, although Article 2, Protocol number 1, does not give rise to an obligation to subsidise any particular type of education, Article 14 nevertheless requires that any subsidies which are made should not be made in a discriminatory fashion. Article 14 prohibits treating differently, without any objective and reasonable justification, persons in relevantly similar situations. Now, just to make it clear, before I proceed with this, continue with this argument, we're not saying that because state schools are subsidised, that the Christian schools need to as well. We're not asking for subsidy. What we're saying is, because state schools are exempt from VAT, we should be exempt too. And we'll see why this isn't an academic argument, because the argument is, well, look, if the state had to pay VAT on school fees, then it would just be giving with one hand and taking back with the other. It's just a circular passage of money. But that isn't the case, as we'll see. State schools charge for a whole variety, are entitled to charge for a whole variety of services, including state boarding schools are entitled to charge, state academies, boarding academies are entitled to charge boarding fees, and that's all free of VAT. So the parents who go to the state boarding school don't pay VAT on their boarding fees, they don't pay VAT on the food that's provided, whereas the private schools are now having to put VAT on. And we say that it's not the subsidy, but it's the tax regime which has now become discriminatory because of this tax measure. And the authority, I'd like to look at Guberina and Croatia, which we had a look at before, tab 58, 1839. And this was a case where a father was not able to obtain a tax exemption for a house he had bought in order to accommodate his child who had serious disabilities. And the authorities claimed that under the tax law, a flat that he previously had was deemed, as a matter of law, to be suitable for a person with disabilities. And so no tax exemption could be given for the father having to buy the house. But the father was saying, well, look, my child has particular disabilities that mean that this flat isn't suitable. There's no lift to get in and out of the flat, for example. And the government was saying, well, sorry, the law says that it is suitable, and that's that. And so this was, as was discussed before, this was a Claimants complaint. But it wasn't a group of people who happened to have the same disabilities as that particular child had. It was that particular child. It was the individual was discriminated against. But the passage, we looked at this before, but I need to look at it again. So I want to highlight a different part of this passage. And this is paragraph 73 on page 1864. On the one hand, wide margin is usually allowed to the state under the convention when it comes to general measures of economic or social strategy, for example. This also includes measures in the area of taxation. However, any such measures must be implemented in a non-discriminatory manner and comply with the requirements of proportionality. And this is the point. The non-discrimination requirement doesn't get lumped into a proportionality assessment. And we saw that in the Rhine Gemeinschaft learning case before. You can't have a discriminatory regime. If it is, then that's the end of it. If it's leading to discrimination, and proportionality is a separate assessment. Now, it may be justified, and it turns out not to be discriminatory as a result of the justification analysis, but that's not a proportionality analysis. And then we see this in paragraphs, I take the court to paragraphs 88 and 89 of Guberina, page 1868. In justifying the decisions of the domestic authorities, the government advanced two arguments. They argued first that the relevant domestic law laid down objective criteria for establishing the existence of basic infrastructure requirements of adequate housing, which left the administrative tax authorities no room for interpretation in individual cases. And secondly, that the applicant had not met financial requirements. And then at 89, the court cannot but observe that the first argument virtually amounts to a concession on the government's part that the relevant domestic authorities were not empowered to seek a reasonable relationship of proportionality between the means employed and the aim sought to be realised in the applicant's particular case. Therefore, contrary to the requirements of Article 14 of the Convention, they were unable to provide objective and reasonable justification for their failure to correct the factual inequality inherent in the applicant's case. By contrast, the Divisional Court at paragraph 133 of their judgment said this: in our view, it may in principle be justifiable for a legislature to prefer a general rule with no exemptions over a system which requires fine and potentially invidious distinctions between categories of individuals who qualify for an exemption and categories who do not. But we say that by endorsing this inflexible rule, the Divisional Court and the government ensure, just as in Guberina, that the law will inevitably fail its proportionality requirements, simply because it doesn't have the possibility of any exemptions. Unlike, and again, take the court back to the case of Begbie, unlike the case of Begbie, where there was provision for individual assessment of individual cases. So,
are you saying that in a tax measure, Parliament can never have a bright line?
I'm not making that submission, but I'm making a submission with regards. If the tax measure was found to be discriminatory, then problems could arise. The problem here is that we had in Guberina, and we say in this case as well, we have discrimination, and the government's answer in the face of that discrimination is we can't have any mechanism to decide individual exemptions. I wanted to say more about this tomorrow when I deal with proportionality, because, and when we look at, again, I said we'd look at the court fee cases, which we say are a parallel, are analogous cases where you have an interference with a conventional item in those cases where no exemptions were made. So factually, I refer the court to with regards to explaining the distinctions between the different types of schools in this country. This is dealt with in the witness statement of Susan Whitehouse, tab 23, page 196 of the supplementary bundle, but also in Peter Lowe's witness statement, and this was evidence that we put before the court and which the divisional court didn't object to, tab 11, page 61, and that explains in more detail the differences between the different types of schools. What Peter Lowe's witness statement shows is that of the two types of independent schools, which are governed by the legislation as independent schools, we have on one hand the private charitable schools, and then on the other hand the academies and free schools. And what his evidence shows that these bodies are constituted legally the same way, constituted as charitable companies, limited by guarantee, and both of them exercise the same ownership of their assets and control of the school independently of the state. They're both free to set their own curriculum, they're in charge of admissions policies, they set staff salaries, they're free to hire staff who do not have formal teacher training certification. And Peter Lowe shows not in that witness statement, in the second witness statement, in fact, he points out the highest paid headmaster in the country wasn't the headmaster of Eton, but it was the headmaster of a charitable trust, of an academy trust, who was paid well over £500,000 a year when these figures were compiled. So we say that the United Kingdom treats, with respect to its VAT legislation, very differently two types of independent schools, private schools on the one hand against academies and free schools on the other, each of which is legally identical according to the only legally relevant features that Strasbourg identified in X and the United Kingdom. And we say that in those circumstances, the difference in treatment cannot be justified and constitutes unlawful discrimination as far as those schools are concerned. And I said I would show the court where we can see that the state schools, state-funded schools, are able, in fact, to charge parents for a variety of services, and that's dealt with by Peter Lowe in his second witness statement, tab 21 of the supplementary reference bundle, page 153. But we can also see it set out in a bit less detail, but set out in the Department of Education's document, charging for school activities, dated May 2018, which is at tab 48 of the supplementary reference bundle, page 401. Document starts, and then we can see at 405 the schools can charge for extracurricular activities, school trips, materials, stationery, computers under the optional extras section. Then 406 we see music lessons can be charged for, and 409 we see boarding fees for state-funded boarding schools can also be charged to parents. Didn't see a mention of meals there, but that is a matter that the court can take judicial notice of, that state schools, unless there are free meal schemes in place, will be charging parents for meals. And the relevance of this is that these very same goods and services now, since the VAT measure has come into force, the private schools are required to charge parents VAT for. And we had a look at this document before, which is on page 535 of the supplementary reference bundle. And starting at page 537, we can see how there are 4 columns there. So we see the first column is type of supply, and then we see the current treatment. So we see all sorts of fees are exempt. For example, boarding fees is the first one mentioned. And then we see afterwards what's going to happen once the measure comes into force. We see that VAT is now applicable. So and we see that for a number of different services which schools are providing. And we can see there that a distinction, a difference in treatment has now arisen between the private schools for having to charge VAT on all sorts of things that they were previously exempt for, just as the academies and free schools continue to be exempt from, and that's to the detriment of the parents who are choosing that sort of education. We say that's discriminatory. There isn't a justification for that, and it leads to a breach of Article 40, considered with Article 2 of the first protocol.
Right.
That concludes my submissions for today. That just leaves the proportionality, which I've dealt quite a bit with proportionality on the way, but there are a few other points.
15 minutes on proportionality.
Yes.
Perfect. Well, we'll see you all at 10:30.
What, right?